Hello and good morning, everyone. Thank you all for attending our Intellectual Properties 101 webinar. We are going to allow a few moments here to have everyone log into this webinar. In the meantime, just a couple of housekeeping items. If you have any comments or things for the presenters, please feel free to use the chat. We encourage that. It's a great way to learn some best practices. However, if you have a question specifically for our presenters, please use the Q&A box. This will help us keep track of your questions to make sure that we do answer them. As this is a webinar, we will try to answer them in the moment, but there will be moments where we do break for questions and answers. So again, please use the Q&A box rather than the chat for any questions that you may have. Again, we're just going to allow a few more moments here to allow additional participants to log on to our webinar this morning. All right, looks like we have a majority of people who had registered log on. So Lou, if you want to go ahead and take it away.
All right, good morning, everybody, and welcome to Intellectual Property 101, presented by the Maricopa Sbdc. I'm Lou Farina. I'm going to be your host today. We've got a couple of speakers that we're going to introduce here in a little bit, but first, let me just tell you a little bit about today's program. Having an idea that could be monetized into IP is really on the minds of a lot of entrepreneurs. And, if you've got intellectual property, you really can't afford to ignore it. It's an asset, and it can be a springboard to opening a successful business. So, but for today, we're gonna talk about our guest speakers are going to talk about what is the USPTO Patent and Trademark Office, an overview of intellectual property types. We're going to talk about patents, trademarks, copyrights, trade secrets, why innovators and entrepreneurs should consider protecting their IP, and how to get started protecting your intellectual property. So again, I'm Lou Farina. I'm your host. I'm a business analyst at the Maricopa Sbdc, and my specialty is technology commercialization. So I tend to handle a lot of the technology-based businesses, and intellectual property is always a key subject. So let me first, before we start, let me tell you just a little bit about the Sbdc. It is part of a national network, and we have an Arizona network also. So each state has a network. This is the Maricopa Center that that's presenting. In the Maricopa Center, there's 17 different counselors, all with different expertise, very broad background. And again, there's 10 different centers in Arizona. So if you happen to be located anywhere else in Arizona, really, we have the whole state covered as far as geography. Here's our website. We do three main things here: counseling, and it's all no fee. We're a no fee service, prepaid by your tax dollars. We do counseling, which is one-on-one with clients. This webinar would be considered training. So I'll talk to you a little bit about more about some of the upcoming webinars that we offer. And then there's some resources, and I'll talk to you a little bit more about that. So from a counseling perspective, here's the broad array of different services and areas that we cover. In the last year or so, we've done a lot of disaster loan assistance, although that wasn't our primary goal, our primary charter pre-pandemic, but a lot of PPP EIDL assistance as needed. We do a lot of lender readiness preparation. So if you're in the SBA, looking for a traditional SBA loan, a 7A, we typically can help you prepare for that. There's marketing. We have some expertise in buying and selling businesses, manufacturing expert, again, technology commercialization. We've got some expertise in international trade and export. And then we've got another arm called PTAC that does government contracting. So let me just talk to you a little bit about these resources. And these are no fee resources to our clients. And it's actually a really good deal because they actually are fee-based if you were trying to access them from outside the Sbdc. So we have something called Growth Wheel, which is a great tool to help focus and drill down on specific areas of your business. We've got something called Live Plan. LivePlan is a business planning tool. It's a very intuitive online platform that helps, especially folks who haven't done business plans before. It'll help kind of guide you through. LivePlan on the outside is probably $20 a month fee. Again, for us, there's no fee. We can provide a license for you. We've got ProfitSense, which is a financial analysis too, and you'll see SageWorks is the data that it uses. So it's really powerful if you got an existing business and you want to take a look at your financials relative to other companies in your area, in your NAICS code. We can benchmark you and compare you. So that's really, really powerful. Got a couple market research services. The SBDCnet.org is kind of a custom in-house research service. But the one I use probably the most is IBizWorld, and that is an external service that provide market research reports. And these reports can be really critical for anybody who's in the startup space, especially if you need some third-party data to validate, the market. We can provide these reports to you. These reports are, probably $1,000, $1,500 a piece if you bought them on the outside through the SBDC. They're free, and there's really no limit to our ability to provide them to you. Okay, if we're going to take a quick poll now, Laura, I'm going to turn it over to you.
I'm going to go ahead and launch this poll here for you all to answer. We'll allow a few moments for you all to answer. It's just about your experience with intellectual property. Where are you at with it? Are you just learning about it? Are you trying to figure out if your idea is patentable? Are you on the beginning ends of research? Have you already filed for a provisional patent? Have you filed for a non-provisional? Or have you already been issued a patent? So this will help our presenter get a better understanding of where you're at as far as your experience with intellectual property. So we'll allow a few more moments here for people to answer. Looks like we've got about half of you who have answered. And I'm going to go ahead and close that poll now. So thank you all for answering. And we're going to go ahead and share those results with our presenters and also with you, Lou. So it does look like a majority of you are learning about intellectual property. So awesome. I'm so glad to have you here. This will be a great webinar for you all to attend.
Terrific. Thanks, Laura. So now for our main event. So we've got a couple guest speakers. Our first guest speaker is going to be Wayne Stacy. I'm sorry. He's the regional director of the Western region of the U.S. Patent and Trademark Office. He's located in San Jose, and we're really, really excited to have Wayne, and really lucky that we were able to get his time to address our local small businesses. The other speaker is Kori Tueller. Now, Kori's a local resource here. She is the assistant administrator and patent and trademark librarian. And she serves as a patent and trademark librarian for Arizona's Patent and Trademark Resource Center here locally. So she's going to talk to you a little bit about some of the resources, some of the local resources available. Okay, I am going to ask Wayne to share his screen and start our main presentation. Perfect. Wayne, I think we lost your audio. Laura, can you hear him?
Yeah, it looks like Wayne is muted. Let's see if, I think he had to phone in because his audio wasn't working on his computer. So let me see if I can find his phone here and unmute him. All right, let's see if he will unmute. Wayne, if you could check your phone. I remember you had phoned in. Let's see if you can unmute that there, and maybe we can get your audio going.
Laura, there is a panelist that has a 909 number, so maybe they're not able to unmute themselves. I don't know if that's Wayne.
That might be, yes. And I did send him a request to unmute. It shows that he was unmuted. Wayne, do you want to try speaking again?
Can you hear me now?
Perfect.
can.
Yes, we
Perfect.
can.
Excellent.
There we go.
Here's Wayne.
There we go. Sorry about that, everyone. So you answered a few questions for me to help understand a little about what you're interested in. Let me tell you a little bit about my background so you know where I come from. I think you should always know where teachers and people presenting information, what their viewpoint is. I joined the federal government for the first time in June of last year. Took an appointment to lead the Western Regional Office for the USPTO. The 24 years before that, I spent in big law doing IP litigation and IP counseling for some of the biggest law firms in the world. And in that process, probably about 2/3 of my work was for emerging companies, startups, emerging companies, and mid-sized companies. And that's what I really loved. Later on in my career, I started gravitating, working for the Fortune 50, the biggest companies, and got to a point in my career where I realized that mid-sized companies, small companies, startups, that was the most important part of the American ecosystem. It's what made all of our technology just boom over the last 25 years. And so I wanted to spend the last part of my career dedicated to helping the IP system grow and really extending it out to smaller and mid-sized companies. But along the way, it's not just IP. I was doing a lot of due diligence, selling companies based on their IP, and I saw a lot of good and bad practices. So a lot of practical experience coming from what I saw. And I'm going to share two things that I saw. One, in many cases, IP was critical. It's what drove the sale. And a lot of times, big companies, a larger company can build it themselves once they see your idea. So IP is important for protecting. I also saw in other instances, people spend huge amounts of money on IP and not on their sales, not on their product development. And the shift caused the company to fail. So IP is both a blessing and a curse. So you have to balance it and manage it properly. And so I'm not here to tell you that IP is the only route. I'm here to tell you what IP can do for you, and then challenge you to think about where it fits into your particular business. And to do that, I want to make sure that this is interactive. I can't see people who wince in pain when I tell a story and they say, "Oh, well, I've done that path." So pop into the Q&A and ask your questions there. I've taught for 20 years at law schools around the country, so you're not going to disrupt me by asking a question. I can use that to build and make this a little bit more interactive program. So instead of talking about patents, trademarks, and copyrights, I like to start from the idea of what am I protecting? What's the goal? And this is really the initial question of where do you want to get to? And anybody that starts the question at, do I need a patent? Do I need a trademark? That's the wrong business question. The right business question is, what do I need to protect? Where do I want to get? And to do that, I'll show you the most important slide of the day. This is everything in one place. I'm not going to read it to you. You'll have access to it. But this slide kind of gives you the cheat sheet of everything you need to know. But I do want to talk about the categories so you can at least think about where you would go. One is the utility patent. That's what people classically call patents. When people talk about patents, it's a shorthand for utility patent. This is the Thomas Edison patent. This is the John Deere patent. I mean, these are the classic inventions that you hear about and think about. The issue that often comes up on utility patents is a little bit of the myth out there that software is not patentable. And that's a gross oversimplification. Software can be tricky to patent, but a lot of the biggest companies in the world are built upon patents that protect software innovations. but it's tricky and you have to get into that discussion. So I always push back on that number one myth that people say, well, software is not patentable, I'm not even going to think about it. You should think about it. You may choose not to go down that path for various reasons, but you've got to at least work through the process. Design patent is something very special. That's related to ornamental designs. You see it that cannot be useful. So that's the definition there. They're three-dimensional type objects often that are interesting but not useful in themselves. So one of the largest design patents acquirers in the US is Nike on its shoes. And it helps people, keep people from knocking off these attractive designs and then kind of trading on those types of work that's done on the front end. You see that the examples we give there, the unique shape of an electric guitar. Now it's got to be shape. It can't be related to the sound that it creates. And the design for a lamp. Some of the great lamp designs started with these design patents because it's purely ornamental. It doesn't really direct how the light works. Compare that to a lampshade, just a standard lampshade that really takes the glare off light and has some useful pieces. So if you're in this artistic arena of building objects, 3D objects especially, design patents become very important. They're much cheaper, much faster to acquire, have a little shorter lifespan. Plant patents are something very unique and rare. And if you're in the plant patent business, ping me and we can talk about it separately. But usually anybody dealing with plant patents has their own counsel on that issue. Now, copyright becomes an interesting thing. You'll start seeing copyright very bleeding toward design patents a little bit because it's about ornamental design. But this is the classic. I wrote a book, I wrote a song, I drew a picture, anything like that becomes copyright protectable. It's got an incredible length of time. You can basically 70 years plus the life of the author. So Mickey Mouse, for example, for Disney still has protection on it even though it goes all the way back to the 20s. Trade secret, and I should also mention, by the way, copyright, something you can handle yourself. The Copyright Office has a wonderful self-help process, and it's relatively cheap compared to utility patents, which are not relatively cheap. They're expensive. Trade secret, just like it sounds. This is something I'm choosing not to disclose to the world. Now, the key for trade secret is it's something that the world can't figure out on their own. And one of the classics everybody always talks about is Coca-Cola's formula. And the key around that formula is not that it's just secret, but all of the security measures they put in place to protect that trade secret. So to be a trade secret, you have to prove that you tried to protect it, and then someone managed to steal it from you despite your protections. So in many ways, trade secrets can be expensive because you have to go through all of these mechanisms to protect. But trade secrets are a very broad category. This could be the secret for making your company's product, or this could be the customer list and your sales tactics, things like that are confidential to you and something that you keep internally. And those really relate more to employment law practices. So when you think about trade secret, it goes all the way from high technology, how I'm going to manufacture my semiconductor, all the way down to business practices that are unique to your company and kept secret. Trademark being the last piece, this is what you classically see. These are brand names like Coca-Cola, Nike. Those names, the key to that is they indicate a source. And this is so you can protect a brand that you build up. You can invest in your name and people know that your name represents a certain type of quality. And that's why counterfeits are such a horrible thing, because they ruin a company name. It's just like people speaking bad about you. They're running down your name. Counterfeits tend to run down company names. And so with trademark can last forever as long as you're using the name to tell people that you're the manufacturer, that you're the creator, you're the source of those goods. So it really doesn't have anything to do with the specific technology. It's an indicator to tell the world who's making your particular product. So as you go through those again, they really, if you look at expenses, trademark, moderately expensive. A lot of it you can do yourself, though it's often good to have a little bit of advice. Utility patents, the most expensive, probably the least that you can do yourself. You tend to need attorneys to at least help finalize that process. You can do it yourself. It's perfectly legal to do it yourself. I'm telling you from my experience, there's usually a lot of cleanup to do because it's a very, very meticulous, legalistic process. And then copyright, cheap, something you can always do yourself, and often encourage people. Throughout my career, we'd show people how to do their own copyright work and let them do it from there on their own. So those are your categories. If you don't take anything else away from today, at least you can look at these and say, well, these are my options. Which ones should I consider further? And that's the best business process I can ever recommend for anyone, is just going through this list from left to right and saying, what should I do or what should I consider? So I put this out there because a lot of times people stop when they hit one. They're like, I'm going to do a utility patent. But the reality is there are multiple things you should consider in any product. You know, I use the iPhone as an example. Everybody knows how much technology goes into that. But what IP protection went into that? Well, the answer is everything. You look at the trademark. We know that this is Apple. You know that the mark with the apple and the bite out of it. There we go. That tells you who manufactured it. You see the word iPhone. Those are all classic trademark indicators that you know when you pick up this phone, it was made by iPhone or by Apple. In terms of patents, the iPhone has tremendous number of patents through it, from the software to the hardware to the glass on the front, the Gorilla Glass that came from Corning. Some of the patents belong to them. Some of them belong to third parties that they license them from. So those are the classic utility patents. And a lot of times in a live class, when I ask, how's the iPhone protected, people look at patents and stop right there. They forget about everything else. But all of the technology in the world in that phone wouldn't make a difference to me personally if I was buying, if I didn't know it was from Apple. If it had some other mark on it, probably wouldn't end up buying it. Copyrights, the software that's on it, the instruction manuals. My favorite that was added by someone for me is Ringtones. And those ringtones, you can get the licensed ringtones from artists. You can get the ringtones produced by Apple. That's part of the licensing piece of IP, where how you move it around, how you build a business on this kind of protection. But with that copyright, it allows you to license the ringtone to Apple, to others, and collects revenue on it. Trade secrets, we know there are trade secrets in there. If I could tell you what they were, they'd no longer be trade secrets, now would they? There are things in here that Apple undoubtedly decided just to keep to themselves, maybe a manufacturing process, something like that no one could figure out how to reverse engineer, and that they keep the process secret internally. Only a certain number of people know what it is. The design patent, one of the biggest litigations in the last decade was on a design patent related to this phone, and that's the rounded edges. That was the iPhone design, so that was a design patent. So when you look at the product itself, it's built or protected by really a web of different IP pieces that can be enforced or licensed separately, depending on what needs to be done. So I want to go through some of these in a little more detail for you, so you have a feel on, again, how to sort out what you may want to do. And trademark. So trademarks, you see them with TM for trademarks, SM for service mark, and then that circle R indicating it's been registered with the U.S. Trademark Office. So thing about a trademark is that's different than a patent is you don't have to go to the U.S. Trademark Office or USPTO and register your trademark to have some levels of protection. It does provide more protection, but trademark has this overlap between state and federal. And so there are different ways to use a mark, but usually people that are selling nationwide look for trademark protection on their goods for two reasons. And this is the key thing people forget. They say, well, my product, I'm worried about protecting my product. But a lot of times what happens is people end up launching a product and they find out somebody else has a trademark or somebody else is using that brand name in another market for the exact same product. And then that causes massive problems. If you're the second, often you lose. You're going to have to go rebrand your product. Sometimes you have to end up recalling your products, taking the names off of them, all sorts of things like that. So you really have to think about, one, protecting your own name, and two, avoiding other people's names. And that's the piece that people don't think about. You are required to avoid other people's names if you want to steer clear. So, I live next to wine country here, and I'll give you an example. One of the things they do before they launch a new wine or put a new wine label out is they do a clearance search. And they go through and work with all the databases around the country to look and see, is anybody else selling wine with a name that looks like this one? And if they do, then they rename it. And we had one company that actually thought they did the right thing. They did a clearance, but they missed something. They printed a bunch of labels, pushed a bunch of bottles out, and then found out somebody had that exact name that they were marketing wine under on the East Coast. So this company had to recall all of its bottles, reprint all of its labels, go through that big headache. And so you really want to think about protecting your own name if you're going to build a brand behind it. And number two, you want to think about avoiding other people's names. Another thing that's recently popping up in trademark is Amazon's brand registry. And it's something if you're selling products on Amazon, I encourage you to take a look at with Amazon trying to use trademarks to help stop counterfeit goods from coming in. So it's something to think about now because the trademark registration, the act of registering, can give you some real protection on certain e-commerce platforms from counterfeit goods. So why the federal? I told you there were a couple of, you could do state, you could do federal. Well, the one thing about the federal trademark, and it's the third bullet point that's probably the most important for you here, is it gives you the right to enforce nationally. You're not limited to your state, and it gives you the right to use federal courts. Now, most people are never going to want to go into court, but just having that option, kind of that hammer, helps kind of make negotiations a little easier if somebody else is using a mark that's very similar to you. The other thing it does is if you're importing goods, it helps with customs on maybe capturing some of the counterfeit goods coming in into customs. So there are several upsides to having that federal trademark registration, but it's different from patents. In patents, if you don't seek a patent, you may lose the right to ever seek a patent. For trademarks, there are examples of companies that ran for years and built big brand names and never got a formal trademark. And then later on, they could go back and protect it. Not the best way to do things, but it's really about the public and telling the public where the source of goods come from. So it's a little more lax in terms of building your trademark or building your brand later on. The biggest issue, again, you've got to look at on the front end is clearance. Am I plowing straight into somebody else's name? And if they've got a registration, are they going to threaten to take me into court? They're called cease and desist letters, and they can be unpleasant if you didn't check your name. The more local your business is, the less likely you are to run into other people's names. But I've seen restaurants, I've seen businesses selling in one town run straight into big national brands. And it's just a common problem. So what are the trademarks? What can you really protect? And this is something that sometimes people miss. And it's anything that indicates source. So you can do the word mark, Coca-Cola. You can do what they call that special form mark, but again, calligraphy, something more than just the letters. Why? Because it indicates, you see that, you know that it's Coca-Cola. The design mark, that's just any kind of design. Nike's Jumping Man is a classic design mark. Doesn't say Nike, but you see that and you think Michael Jordan, Nike. Those kind of images build brand recognition even without the words. So you can protect a picture by itself if it indicates your brand name and your source. And then what they call the composite mark, which is just the combination of words and drawings. And the key to all of these is that they tell the buyer who made the product. And they help sort out real products from fake products. A few other things along the way that I think are important for people to think about as you're beginning to package products. My personal favorite's the Tiffany box. That box by itself, it's just a box. But that color blue, that ribbon tells everybody it's a Tiffany box. And they worked hard to build a brand recognition around that. So no name, no picture, but that box is protectable in itself. The shape of something, the Coca-Cola bottle, the Hershey Kiss. And I challenge you, this particular image of the Hershey Kiss has the little tag that said Kisses on it. But if I took that tab off and I handed it to you, what would you think it was? You'd recognize it as a Hershey's Kiss. And so that image, that silver, that shape, and even now the red and the green ones they put out for Christmas, they all tell you something about who manufactured the product. When you're picking a name, there's kind of this sliding scale of names. And the more descriptive, generic the name is, the harder it is to get federal protection. So we'll go through a few examples, but if you think about that, if it's generic, it's hard to get protection. If it's just made up, what they call fanciful or arbitrary, it's easier to get protection if no one's using it. And so you have to really think about how you name your company or name your product. Generic and descriptive really helps sell the product, tell people what it is, but that's the hardest thing to get a trademark on long term. So here's a good example of what you can see. Strong marks, Xerox, Microsoft, Cisco, they're just made up words. It's funny, Xerox became so popular that now it actually has meaning, at least to a certain generation, is the act of making a copy, but originally just a made up word. Arbitrary words, they don't have any relation to their product. Apple's is the best example of that. Apple has zero to do with phones, computers, software. So they just picked this name and then built the brand around it. So those are arbitrary marks, much easier to protect than when you get down to the generic category. So suggestive, these begin to get difficult because they tell you what's going on. Copper tone, ever ready for batteries, those types of names can get protection, but it's quite a bit harder until they've been used and people start associating them. We look at it now, I see copper tone. I think of suntan lotion, not because of the words, but because of years of their advertising. The same for ever ready batteries. They built a brand name around it. So sometimes to get federal protection, you may need to invest in getting public recognition in these suggestive names. Now, weak marks. These are marks that describe the goods or services. Just, it's like realtor.com. Well, that would be classically a weak mark because it tells you exactly what the service is. Lawyers.com is the one that's here. Though, the interesting thing about these generic marks, they may be protectable if you spend enough time putting resources into building that name. So they're not necessary, they're not forbidden from being protected, but they are rare, and it's usually a big fight. And when they are protected, it's usually after years of investment in them to show that they have a meaning and build up a meaning. So, realtor.com may be getting close to building up that kind of meaning because they've advertised it for years. Today, I saw an advertisement or last night for apartments.com. They're trying to build a brand name around that very generic term, but you have to invest in it. Different than using Apple or Cisco, which don't need that kind of buildup early on. So with that, that's why I tell you, if you're going to pick a name, you want to be thoughtful. You want to think about clearing that name to make sure you don't get a cease and desist letter. And then when you look to protect it or invest in it, you're going to start building recognition. And to get federal protection, it doesn't have to necessarily have nationwide coverage. You can build up local protection also, and that helps with restaurants and those types of things. If I'm operating my restaurant in one area, I name, so maybe somebody else can use that same name in Maine because there's no confusion between people. But it's harder if it's a national chain along those lines. The classic example I think of, because I saw Coming to America 2 is now streaming. I remember in Coming to America, the original, the restaurant was called McDougal's and was obviously a knockoff on McDonald's. So those are the types of things that are classic clearance issues that could cause some significant problems for you down the line. Trade secret. So I've got something that I can keep secret, and that is the key. It must be something that you can keep secret. If it goes to the public, if the public can reverse engineer it legally and understand it, it is not something that is ripe for trade secret. Anything you are going to disclose is not a trade secret. So that's a pretty clear line on that front. I love that they talk about Colonel Sanders and the secret recipe for KFC. Yet I go online and I can find the recipe. So I always wonder why people use that example as a trade secret, but it actually is a good example of a discussion that is reverse engineerable, that's been out there. Is that really a trade secret anymore? And that brings up that idea that it can be a trade secret for years, and then you can lose that either through negligence or just dedicating it to the public. Coca-Cola today can put that out there for the world and lose their trade secret protection. They're not going to. If somebody steals it and tries to put it out there for the world, that's a different issue because they have security measures. But trade secret's not forever. You have to keep it up. So copyright. And before I do that, if you have questions on trade secret, kind of the level of security that's required, it's a difficult, unsatisfying discussion. How much is required? And most of the rules talk about you have to have a reasonable amount of security for the importance of the trade secret. Coca-Cola doesn't let one person know the entire trade secret. It's kept in vaults. They have security forces or security procedures to deal with it. So tremendous set of restrictions. But what if it's a confidential customer list? What do you need to do? Well, if it's just available to everybody in your company, unrestricted, maybe that's a real problem. But if you have access restrictions on your computer that only certain people can access it, and those people need to access it, that might be sufficient. You really have to start looking at individual situations on what's required there. It's not meant to be onerous. It's just meant to show that you value this information and you're going to take steps to keep it out of the public hands. And if you're not going to take those steps, then the courts won't take the steps to do it for you. Copyright. Classic issue you always see: books, music, drawings, anything like that falls in the copyright category, as long as the single requirement, it's fixed. It's written down, it's recorded somewhere permanent or semi-permanent. And that's the key to all of this. So if you take pictures on your iPhone, those would have copyright protection. Most of us have had the experience of wedding photographs. Those are classic issues about copyright protection. If you go look at the wedding photograph contracts, the wedding photographers most typically keep copyright ownership. That way, if you want to buy pictures, you have to buy reprints from them. And if you go to the local CVS or any store that has a copy machine, and you try to put down a bunch of wedding photographs to copy them, usually they'll come out and stop you because they don't want to be part of the copyright violations on those particular issues. It's just that common. So that's the type of thing. If I have a picture, if other people want to use it, then that's a copyright issue at that point in time. And with the proliferation of cameras, video, and still pictures, copyrights become a big issue again at that point in time, or at this point in time. The one trick on copyright that people often ask about is, well, what if I got an idea and I create another work based on that idea? Sometimes it's spoofs, funny commentary about copyrighted work, and those are the types of things that may or may not be permitted. There's a whole body of case law on it that tells you whether you can use somebody else's work to make social commentary. At a high level, the thought is, if you're using somebody else's work to make money, or if somebody else is using your work to make money, then there's going to be a problem if you've gone through the process of registering your copyright. So that's something, as you're building your business, or as you're looking at other people maybe using your ideas, you want to be very thoughtful about that. And there's just that level of practical common sense behind it. Is somebody making an unfair profit? And that's not going to be the final legal determination, but at least guide you. You have a feel if somebody's using your work to make money, or is somebody really using your work to make a social commentary, and you kind of get the same feel if you're doing that to somebody else's work. Copyright, as opposed to patents, basically unlimited in time for practical purposes. It's 70 years plus the life of the author. It's long enough that it's not going to bother most creators. Patents, on the other hand, are 20 or 15 years. It's a much shorter time frame. So something to keep in mind. It's not a big issue, other than it can last a long time, and it provides a stream from generation to generation. And that's usually what happens, is you see the grandchildren that are getting the royalties from a book written 40, 50 years ago. So it really does have a multi-generational royalty stream that you don't see in patents because of the lifespan. So let's move to the idea of why register. So when you put anything down, it automatically has this idea of protection on it. People can't copy it. Now, you may not be able to stop anybody, but it's protectable once you put it in writing. So why do you go through the process of registering anything with the federal government? It's not the USPTO that handles copyright. There's actually a copyright office that sets separate from the USPTO. But the main the main benefit for copyright protection is it does give you the power of federal courts, and often the hammer of federal courts for if people think that they're going to steal your work or knock it off. And again, that's a big issue today. So copyright can help with getting access to federal courts, can help encourage other people to stop copying your work. The U.S. Customs and Border Protection, so in other words, you have the ability to seize at the border. This made a huge difference when things like books were being imported. It's a little bit trickier when the infringement and the theft is electronic. But the registration gives you a lot of power to protect your work. And then again, avoid litigation by discouraging people from doing bad things on the front end. The most important thing, though, is it's not enforcement, it's the ability to license. It's the ability to get revenue from your work. And from the other side, it pay revenue to people so you don't get sued. But the registered copyright can then be formally licensed for a royalty rate. So it's how you can monetize your content. So patents. We'll spend a little more time here on this because patents are probably the most complex piece of the IP system. And like I said before, you can do a lot of the patent work yourself. Technically, you can do it all yourself. Those patents tend to have difficulty in licensing transactions, tend to have difficulty in enforcement because they miss a lot of the necessary components. And when lawyers get involved, they can tear them apart very often. So what I want to do is talk to you about the expensive patents, what you can do to maybe reduce that expense for emerging and startup companies. I know the key fee is not the U.S. Patent Office because they have reduced fees for all of small companies and micro entities. The real issue is the outside attorney's fees. I mean, attorneys, patent law attorneys are incredibly expensive because they're somewhat unique skill set. So how do you work with them while minimizing cost and getting the necessary protection? The first thing I want to make sure everybody hears is date. If you don't file for a patent in the right time frame, you lose the right to file for a patent. That is different from copyright. That is different from trademark. If you delay, you can lose the right to file for the patent. Now you can still build your product. It's not going to interfere with that, but you can lose the right of protection. They refer to this as a grace period, but different countries around the world have different views. And the most conservative view is if you disclose your invention to the public, you've lost the right to file for a patent. In much of the world, it's that harsh that if you disclose, you lose the right. It's already in the public domain. The public has access to it. You can't pull it back. So if you're going to file for a patent, you have to think about this early, before you write that paper, before you go to a trade show, before you show an investor. You have to think about this. Now, there are restrictions and nuances all around that. But the best thing you can think about is before I show it to anybody that's not my company, I need to at least make the decision whether I'm going to file a patent or not. I'm not saying you need to file one, but you've got to make that decision. I have counseled company after company that was short on funds, delayed the patent that they needed, the patent filing that they needed, and then later on tried to go back and capture it. Impossible. So then we're trying to capture all of the small add-on inventions, the little commercial things, but they lost access to the key and core components. And then anybody in the world is free to use them and knock them off. So that would be the second thing I'd want you to take away from today. Patents have to be thought of in the first part of your company setup, the first part of your company launch. You cannot delay at least making a decision on what you're going to do. So what does a patent give you the right to do? And this is one of the myths, and it's partly people use shorthand. They don't focus on the language exactly. But a patent does not give you the right to build your product. It gives you the right to exclude others from making the product. And often that means you have the right to demand others pay a royalty if they're going to use your invention. So it does not give you the right to build it. It gives you the right to keep others from building it, or the right to require them to pay some kind of royalty if they're going to build it. Again, does not give you the right to make it. And you think about classic pharmaceuticals. Pharmaceutical companies will get a patent. That doesn't give them the right to make it. The FDA, Federal Drug Administration, they give the right to make and distribute the product. So they're often separate regimes on that process. They're only good for 20 years from filing, and there is no worldwide patent. If you want worldwide protection, you have to end up going through all of the countries in the world. And what that really practically looks like these days is people end up getting protection in a few key countries for commercial reasons. There are administrative processes that help bring the fees down and minimize burden, but those things do not equate to a worldwide patent. Every patent belongs to one country, and its enforcement is country specific. And a lot of people get surprised by that because they end up with big fees when they say, well, I'd like to protect my idea everywhere. And that was one of the big things I would do and help clean up companies. They'd come in and they'd spend a huge amount of money trying to protect their patent worldwide when they were never going to sell their product outside of the United States and Canada. But yet they would have spent $300,000-$400,000 trying to get protection across the entire world to the detriment of their own sales and their own R&D programs. So worldwide, this pursuit of worldwide patents can be incredibly expensive and incredibly destructive. So you have to think about on the front end whether that's what you want to do. And my first question has always been, where are you going to make your money? Where are you going to sell your product? And then we can look at it from there. But if you're never going to sell a product somewhere, you want to think about why you're patenting it there, just because the cost is so high. So back up here on utility patents, it's a good place to talk about apps and software. And if you Google is software patentable, the number of answers that come back is frightening. The amount of incorrect information is more frightening, and maybe the most troubling is the amount of half correct information. The end result on software, I tell people, is that it is patentable. It comes with some real difficulties, and a lot of software companies will look at patenting software and maybe choose to go a different direction. Now, the code is copyright protectable itself, so that keeps somebody from stealing the code and knocking off the code. Well, anybody that has written code knows that there are dozens of ways to write the code, so there are ways around it. So copyright protection for code only prevents the most heinous type of theft. But the idea of a patent is it prevents somebody from independently coming up with the same idea. That's the difference. For copyright, if somebody comes up with the exact same book as you, and they didn't copy your book, and they can prove they didn't copy your book, that's fine. That's okay. Independent development is always a defense in the copyright world, if you can prove it. A lot of people say it, but then they can't prove it because it just doesn't hold true. But in the patent world, independent development is irrelevant. If you're first, it's yours. And that's the key. Even if somebody with absolute good faith comes along later and invents the exact same thing, they could be blocked by your patent. And the flip of that's also true. Somebody could block you even though you were independent. And I've done lots of trial work, been in front of a lot of juries, And that's something that I hear company after company try to get up and say, you know, I'm an honest individual. I developed this all myself. Here are all my receipts, all my time records. I didn't steal anything. Why are you accusing me of patent infringement? And I've seen people break down into tears on the stand saying, I didn't steal anything. But utility patents aren't about stealing. They're about who was first. And often that feels personal, but that's the only question. Who was first with the invention? And this comes back to that timing. What really matters today in the world is who filed for the patent first, with some nuances around that. But that's the question. Who filed for the patent first? And that's who owns that idea. And anybody that comes along later and tries to use that idea, it's not about theft. It's not about them being a bad person. It's just about them being second. So that is a key distinction. That's different from copyright. That's different from trade secret. In trade secret, anybody can come up with the exact same trade secret themselves. As long as they didn't steal it from the other person, independent development is perfectly acceptable in the world of trade secrets. Patents is the only area that really sets up this. If you're first, you're the winner. And that's the key distinction I try to make sure everybody understands. For patents, if you file first, you're the winner. Now, again, I'm a lawyer. There are always nuances and small caveats and carve-outs for that. But if you're walking away from this, that's what you should think about from a patents perspective. And if you're thinking about if I'm first, I'm the winner. If I'm second, I'm vulnerable. You're at least getting into the right discussion in the right mindset for moving your business forward. You may need more sophisticated advice down the line, but at this point, at least you're in the right place. Design patents, much more economical to file than the utility patent, and they are an odd duck in terms of drafting the pictures. This whole idea of dotted lines on what you're trying to protect, it does require some expertise in drawing. So these are usually done by specific attorneys that focus on design patents. And it is this ornamental design. And you can see a few examples here that we pulled out. You know, I love the chair designs. All these chair designs that have design patents on them keeps people from knocking them off. Another great example, ceiling fans. There are lots of designs on ceiling fans, because if you create something that's commercially appealing, then you don't want people to knock it off. And the design patent keeps people from knocking off your design. Again, if you're first, it's yours. That's just the way it is. Even if somebody comes up with their own design second, independently, in good faith, honest people, this design patent, you're the winner if you're first. But some great things in here, like chairs and sneakers, has been a huge area. I've been reading about recently the Ferragamo Wedge, and the first wedge that was allegedly created. And Ferragamo was launched off of a series of design patents. So the greatest of the Italian shoe manufacturers, we know that name because he managed to win on a series of industrial design patents in the rest of the world, but on a few design patent litigations that gave him control of the wedge. So they can make a huge difference. And by the way, he managed to push his competitors all out. And if you really study the history, nobody's going to know the competitor's name, but that competitor in 1955 was actually a much bigger manufacturer and much more important in Italian shoe culture than Ferragamo was. So being first and having the design patent changed the course. And I've got a question here. Is there good revenue in selling those design patents to companies that want to manufacture them? Design patents themselves, my experience, I haven't seen a lot of direct licensing of them independent of a product. I have seen people build a product covered by design patents that's then taken over by a larger company that has better distribution channels. So you see that in shoes. If you wanted to go look at an example, Crocs, a lot of design patent work around Crocs, and then that was rolled up from a small company backed by private equity from there. So by itself, the patent, I haven't been involved in any licensing of design patents divorced from an actual product. I have seen great success in design patents connected to a successful product going to a company that's got bigger marketing channels, bigger reach. And so that can make a pretty significant financial improvement on the product sales. Plant patents, other than to know that they're there, I won't bore you with them. It's actually fascinating when you start looking at the history of roses and the competitive nature of this industry. But very few people actually are in this space, and they're usually highly advised by attorneys because it's so competitive and so specific. So as we kind of move toward the end here, why get a patent? And I think the answer for you is, one, does it help you with a revenue stream? Or these are the questions you have to ask. Again, the patents aren't the right answer a lot of times, but you want to look at it. Does it help protect a revenue stream? Will it help me either sell my company, license the product out, or protect from direct knockoff? Sometimes you just want to get the product out there and then sell your company to someone larger. Those are great uses for patents. Often patents are collateral for further business loans. We're seeing that more and more as patents become an asset, just like a piece of physical property. And that really can help a business go forward. Of course, that I've also seen people obtain collateral, use it for collateral, but they've spent $500,000 on a portfolio that they're getting $200,000 in collateral for. They've spent too much on foreign patents. So you have to think about it and be careful. Building it up for collateral alone, I have not seen as a successful strategy. Building it up as a revenue stream, that is the more successful strategy that I've seen through my career. Some people like to use it as a marketing tool. Some venture capitalists think that patent pending, basically any kind of barrier to entry is important. If you go back and you watch Shark Tank, it is a regular question on there. They'll ask, how are you protecting your product? And the reason they're asking that is they know that the product can be knocked off if there's no patent protection. And that's kind of the key to a lot of their questions. So I encourage people, go back and watch a few episodes of Shark Tank, and you'll see the investors start asking, or the sharks start asking about IP protection. And what they're looking for is there a barrier to entry that you've created so other people won't just knock you off? So I want to slide forward a little bit and leave you with this idea on the path to patent. There is something, once you come up with your invention, there is something called the provisional patent application. And it's a much cheaper thing to file. It's very limited, but it gives you a year of grace period to try to work through what you want to do, maybe raise more funds. And they are considerably magnitudes of order cheaper on attorney's fees. They give you a lot of leeway. Now, I don't encourage people to use provisionals if you've got the funds to go a different direction, because a provisional is good for 1 year and then it just disappears. Poof, it's gone. But it can give you that 1 year to get your non-provisional put together. And the provisional can't be a half-baked idea. It's got to be your full idea, your full invention. The beauty of a provisional is it can just be ugly. It doesn't need to have all the legalese and all the specialty format. And then within a year, you can convert to the non-provisional application and go through the standard process. So it doesn't save you any money. It lets you delay the process and then preserve your right to be first. And that's the key piece of what that provisional can do. So if you're strapped for cash and you think you need the patent protection, this is an option for you, and it's the provisional patent application. If you're not strapped for cash, maybe not the best option for you. You just move to the non-provisional piece here, do all the full legal work on the front end. So with that, I guess the part of this we build out to, if people have specific questions, we can go into them. But for this group, I wanted to kind of keep it at this level, that provisional patent application, you can avoid that legalese around the claims, all the claim drafting. With the utility application, often you're going to want to get a specialized attorney involved to help with that process. Now, you may be able to do a lot of the work, a lot of the technical work to keep the prices down, but that last bit of polishing is important. So for you, where to go? That's what the USPTO is really focused on. It's different than any other patent office in the world. The rest of the patent offices don't care. They take the applications in, they examine them, they send them back. What we have done at the USPTO is we recognize that patents and IP and the role they play is critical to mid-sized and small companies, that mid-sized and small companies are actually the biggest new job generators for their size in the country. So the U.S. economy booms when small companies boom. And that's what we wanted to do. We wanted to be able to support these smaller companies. So we have reduced fees for small and micro entities. We put in offices over the last 5 years around the country. One in San Jose, one in Denver, one in Dallas, and one in Detroit. Now, I know those places are a long ways away from you, but the point is we put those offices in and then task people like me with making sure we reach out to everybody within that region. So I am a resource for Arizona in the same way I am a resource for Silicon Valley. And in fact, I spend more of my time outside of Silicon Valley by far than I do in Silicon Valley. Other things that are out there, and these are on the website. You can Google the Inventors Assistance Center. So the USPTO has invested heavily in its ability to answer questions when you can call in. The Patent Pro Bono program. We have worked with lawyers around the country to establish these pro bono programs that are based on income, that tie up inventors with some of the best lawyers in the country and push out incredible work product. Law school clinics. So we've partnered with law school clinics around the country. These law schools run these programs tied to lawyers, leading lawyers, and they help individuals draft their patent applications, get them on file, get the process started. So something that's been really useful down the line. And the last thing I'd like to mention here, and this is going to be the introduction for our next speaker, is that the USPTO has invested heavily over the last 2 decades in something called the Patent and Trademark Resource Centers. And these are around the country. And we have worked with libraries, and some of the best librarians in the academic world have stepped up to be the advisors for people coming in. So they offer, and you're going to hear about it, they offer tremendous insight into the process. And I cannot say enough good about these PTRCs and what they can provide people, not just in terms of the resources that you think about a library having. The PTRCs aren't libraries. What makes the PTRCs great are the librarians in them and the incredible knowledge they have. So with that, I would love to turn it over to your PTRC.
Kori, if you're on, you're welcome to share your slides at this point.
Great, thank you, Lou. Let me get my screen sharing going. Can everybody see my screen?
Yes, I can.
Perfect, thank you. And thank you so much, Wayne. Great words and very kind, and appreciate the segue there. And thank you for all of the wonderful information that you've just shared. There's so much to know. And you had great insight, great advice, and really appreciate your expertise and all of the things that you've shared. I want to start with a quick thank you to the Maricopa Sbdc team, Lou and Laura, and the USPTO regional office, and Julie Mason for inviting me to carve out a little space here today to share some of our local resources through the PTRC. So my goal today is to be quick, and you will be getting a resource list with the links that I'll be talking about and referencing, because I know that it's not really feasible to be jotting down things while you're listening. So as I thought about what I wanted to share with you, I'm sorry, let me advance here. I thought about the things that I wanted you to know about the PTRC. And this is not an exhaustive list, but it's just kind of the big bucket things that I thought would be important to get across. So the 5 things that I'm going to talk about today are free, confidential, librarians, not lawyers, navigation, and instruction. So we're going to go through this one by one, but it's not a deep dive. It's going to be a quick and simple overview, and then we can follow up, and you're welcome to reach out to me. So the first area is free. And I've got that asterisk there because what we offer as a PTRC is available free to you, no cost involved. But as Wayne mentioned, applying for a patent or trademark and maintaining those, there are costs involved. So I've got a link to the fee schedule. You should check that out, be aware of it, make sure there are no surprises, and know what costs would be coming your way if you engage and embark on this journey to get intellectual property protection. But the things that we can offer you at the PTRC are free. So don't hesitate to reach out to us. Confidential. We take patron privacy really seriously, but that said, you should be aware of what you share and where you share it. I don't want to know all of your great ideas. I'm excited that you have them, but my role really is to keep the conversation generic so that I can demonstrate using generic examples, and you can protect your information. Now, if you do want to talk more about your idea, one of the local resources that we have is the Inventors Association of Arizona. It's a nonprofit, but it is membership based, so there are costs involved for joining, but that's something that you can check out. They do have closed door monthly meetings, I believe every 3rd Wednesday, and it's virtual in these pandemic days, but everybody signs a non-disclosure agreement. And so it is a safer space with other people who are in the process of also trying to patent ideas. So that's a possible option for you if you're interested. Librarians, not lawyers. One of the reasons we keep it generic is because I'm not equipped to give legal advice. That's not my specialty. I have a lot to offer as a librarian, but I do not have anything to offer because I'm not a lawyer. So in the realm of legal advice. But we do have resources, and Wayne mentioned these. ASU and University of Arizona both have intellectual property clinics where they accept applications from clients and might be able to pair you up. The links in the resource list will include links to their services and their applications. University of Arizona is also the patent pro bono program participant in our state. And there are some income qualifications and other things that need to happen in order to qualify for assistance. I do know that with University of Arizona, and for ASU as well, the number of clients that they can service depends on the number of students in their clinic each semester. And so I believe this past year, University of Arizona helped service about 40 clients. They like to keep it to one applicant, one application per year so they can spread their services. And they really do love to support startup businesses, those who might have difficulty affording an attorney. The USPTO is always going to recommend that you engage with a lawyer, and because it helps protect your investment, but you can do it on your own, and there are supports for that as well. If you are interested in finding an intellectual property attorney, the State Bar of Arizona has an online database where you can filter for an intellectual property specialty, and that link will also be available to you. Navigation. I started as the patent and trademark librarian for our PTRC about a year and a half ago. So I know that feeling of overwhelm when you realize how much information is out there. But it really is an exciting field. There's a lot to know, but there are a lot of supports to help learn. And the USPTO's website has great information, but it's a lot. And so the feeling of overwhelm or maybe confusion and not knowing exactly where to start, that's one of the things that I feel is our strength. We can act as a compass or a guide, and we can point you to the right resources because you might not even know that something exists, so you wouldn't know to ask for it. So if we know that you're starting the process of exploring what's open to you, we can help you figure out where to look. And so friendly local face that is happy to guide you. So take advantage of that if you wish. Instruction. This again is one of our specialties as librarians. We know how to use databases and how to conduct searches and make them successful and manageable. If you were to, these are just an example of two different databases that you would have access to online through the USPTO. There's the patent full text and image database known as PAT-FT on your left, and then there's the trademark electronic search system TESS database on the right. If databases aren't something that you use often, they all have kind of quirks and tips and tricks that would be helpful for you to know how to navigate. So that's something that we can do. Pre-pandemic, people would come in and I could be on the computer and they could be kind of looking over my shoulder. These days, we can accomplish a lot by emails, phone calls, screenshots, or even setting up an online meeting where I can show my screen and show you how to input the term properly and what to select as you're navigating these databases. And one thing I'll just mention really fast, because I'm not trying to do a deep dive, but when you're searching, because you have to know that your idea is new and non-obvious before you apply for a patent, the text is only the database is only full text searchable from 1976 to present. But you're responsible for looking back to the beginning of patent time. So you need to figure out what classification code fits your idea best. And that's, again, another thing that having somebody explain the classification scheme to you might be helpful. There are great resources online, but I'm also happy to be a resource for that. So that's just the broad strokes. Watch for the resource list and the links there. You can visit our website at azlibrary.gov/STARL, which stands for State of Arizona Research Library. We are a part of the Secretary of State's office, which is the State Secretary of State's office is responsible for the state level trademark registration that Wayne mentioned. That's not part of the scope of my job, it's part of business services, but I can direct you their way if that's something that you're interested in. But essentially, if you go to our website, you can find our patent and trademark icon there, which has information and some guides. You can email that address listed or me directly. You could choose the Ask a Question button to get in touch with me. And here, ready to support you in any way that I can. I'm happy to get to know the group and have you get to know me a little bit, and look forward to working with you, whether you're just curious about how to navigate some things or learn about things, or if you're committed and really ready to move forward in securing some protection for your intellectual property. So,
Kori, we did have a question that came up.
oh, sure thing.
Yeah, going back to the pro bono program, someone would like to know if those programs are available to them if they are already working with a patent attorney.
Usually on the application, they'll ask whether you're already working with someone. So I don't believe that I think there might be some room for that. And I don't know if Wayne knows more about that than I do, but my understanding is because it's asked on the application, I don't know if that would completely eliminate the possibility of getting service or not. I do know that the pro bono program, they do more transactional things, not litigation. So I think they understand that you might need an attorney for different purposes. But I'm happy, you can look in the resource link, or I can help navigate that question and try and get a better answer.
Perfect, thank you. I don't see any other open questions for either Wayne or Kori. So if you do have any last minute questions, please feel free to put them in the Q&A. If not, we're just going to go ahead with this webinar for us really quick. We do have a couple of things to tell you about. So if there are no more questions, which I don't see coming in. So Wayne, thank you so much for presenting today. I think you did a really great job of covering all of that great information. And Kori, you as well. Thank you for sharing those local resources to, specifically to Arizona and our area.
Yeah, thank you. And thank you again, Kori and Wayne. That was really just a great amount of information that you provided us, not only insight, but resources that our local businesses can use. Just before I go on, I got a couple slides. Please hang on. We got a survey at the end for you. But from an SBDC counselor perspective, and especially in the tech commercialization area, I deal with a lot of tech companies. And so, one of our roles is, I think with Wayne, what Wayne started with is like, before you go out and start spending money on a patent, let's think about this as a business. And that's something that we can do for you, that I can do for you. It really, the amount of thinking you do up front usually pays off. And, I get a lot of folks that come to me with patents already filed, asking how to monetize it. And sometimes it would have been better off just to have thought about it first. So let me just talk to you just a little bit about our counseling, how it works. You go to this website if you want counseling. That's what would be an SBDC counselor. And if you're probably patent oriented, you'll probably wind up with me. And it's by appointment only. So you register with our service, no fee again, just put some information about your company, and then a counselor will reach out to you and set an appointment. And typically what we do, is there's an initial session where we get to know you. We tell you a little bit about what we do. You tell us about who you are. We think about some ways to move forward, some of your goals, how we can assist. And then there's these follow-on sessions. The counselor and the clients usually meet regularly. And it could be, every month or so, every 2 months, depending on the what's going on with your business. The other thing we can do, and I didn't mention, is as far as referral services go, I know there's the database of lawyers, but at the SBDC, we maintain a pretty robust referral service or referral list that are service providers, attorneys, intellectual property attorneys included, that we can recommend. And we vet them only because we know them, we know they serve our community. We don't know necessarily their pricing. They're not going to give you a deal per se because you come from the SBDC, but we're always happy to recommend. And again, on our side, there's no financial incentives for us. It's just us recommending good resources for our clients. And then, follow on, we track our business goals, track your business goals going forward, and we report metrics. That's the SBDC, where we are no fee, but the way we get, I say, quote unquote, paid is by you growing your business. And if you inject capital, if you spend some money, if you hire people, if your sales go up, we capture that into our growth assessment, and we document it and we report it into our metrics. And it keeps our funders, the SBA and the Maricopa Community College District, happy, and we know we're doing what we're supposed to be doing. Upcoming webinars. So there's lots going on, and I would really go to our this website, our Maricopa SBDC events. There's lots of stuff popping up on the calendar all the time. Keeps us very busy these days. But let me just highlight a couple of things here. So on the 11th, we've got a small business payroll webinar, probably one of our outside specialists. The 24th, there's one of our internal specialists are going to talk about buying a business and how you need to know that. On the 25th, I'll be doing an SBIR overview, how to potentially leverage the SBIR grants as seed money. On the 12th of April, I'll be doing an angel investing program on how it's created, how the pandemic's created some new opportunities. And following on with this series, and in May, we're going to be doing another program just on patents. And early in the third quarter, we're going to do a trademark webinar also. So this is just a sampling of some of the things that are coming up. Just keep hitting our page, and there's things that come up. And also, as Laura mentioned, if you miss it, you can go to our webpage, and they are recorded, and you can see and review on your own time. So again, I'm going to close here. Our website, there's resources, there's all kinds of resources. We were talking this morning, even, there's information on grants, just community grants. We try to aggregate some of that information there, but there's a whole host of resources on our webpage. There's our training event calendar. There's counselor biographies, right? If you see a counselor you particularly like, their biography, you can request that counselor. We also have some social media on Facebook and LinkedIn. Please follow us, and you can stay current on our programs. So thanks for joining us today. And Laura, I'll turn it over to you for the evaluation.
So thank you all for joining us. As Lou said, we will be posting to our website the recording for these. And then Kori was gracious enough to provide us with a PDF of all the resources that she was mentioning. Those will also be sent out to you tomorrow. And typically our recordings are posted either every Friday or Monday. So again, check back with us. If you could please complete the evaluation for us, that would really be helpful in helping us to better understand what to serve you during this pandemic. So this recording will be available for all of you. So if you were curious about the slides, it'll be on our website, potentially on Friday. I did see a question come in about that. So thank you all for joining, and I hope you all have a great day. And thank you again, Wayne and Kori, for joining us today.
Thank you, Wayne and Kori. Really appreciate it.
Thank you, Lou.
Thank you.
Take care.